Thank you. You may be seated. We have one case on the docket today, and that is the City of Miami Beach Police Department versus Doherty. Is the appellant ready to proceed? Yes. You may.
Morning, Your Honors. May it please the Court. My name is Louis Estrada. I represent the appellants. I'd like to reserve 5 minutes for rebuttal. We're here to ask the Court today to reverse the trial court's award of benefits, including compensability of the claimant's hypertension, because the Court inappropriately disregarded the opinion of the EMA in this case, which was requested by the claimant and appointed Dr. Perloff was the EMA. He opined that the claimant's hypertension was wholly due to non-occupational factors that he enumerated in his deposition.
Let me stop you there. Is there any disagreement that the diagnosis is essential hypertension?
I don't believe Dr. Perloff diagnosed him with essential hypertension. There's some nomenclature that is used in the deposition. It's either primary or essential hypertension, and the definition of that seems to have been some of the confusion that led the judge to her ruling.
Because I guess, I see no parties nor the judge addressing Bivens, which says essential hypertension is not covered under the presumption. Was that discussed at the hearing below, or was that addressed with the physicians, or is there a stipulation that this presumption, I don't see a stipulation that the presumption applied.
Well, there is no stipulation that the presumption applies, that's
Right.
for certain.
But how do we get around Bivens?
Well, you mean for the appellants to get around Bivens? Bivens indicated that essential hypertension is not.
Correct.
But
Was
you
there
didn't
any,
argue-
did you raise it? Was it raised by, you're the defense, did you raise essential hypertension is not covered under presumption?
Well, we said there was no disablement, and we said that the claimant's hypertension was not covered under the presumption, whether it be essential hypertension or secondary hypertension, it was not covered under the presumption. And the judge found it was subject to the presumption, and we indicated that based on the EMA's testimony, assuming it was covered under the presumption, it had been rebutted. And he in fact said that. He said it was wholly due to non-occupational factors.
May I ask you, what was the impairment allegedly caused by the hypertension? What was the impairment at issue here?
Well, Your Honor, you mean disablement? Because
Yeah, what exactly is at stake here? 2 days missed of work?
No, a lifetime of coverage of the claimant's hypertension.
I understand that, but what was the consequence, allegedly, of the hypertension?
Well, he claimed that his physician had taken him out of work.
For how long?
Several days, apparently.
So 2 days of missed work is the impairment?
I believe that was the case, Your Honor.
Was there any evidence in the record that indicated, because it seems like the EMA was struggling with this too, that recognizing that, yeah, he had elevated blood pressure, but it really didn't impair anything, and a doctor's order just saying, yeah, I'm going to take you off work for a couple of days.
Well,
how is that a condition or an impairment of health as mentioned in the statute?
Well, the EMA did mention that. He said it was a very peculiar, I believe he used the word peculiar situation where the claimant's blood pressure readings would not have been disabling under whatever appropriate guide.
I mean,
Right, but it's not disabling. Disabling is a separate question. Disabling is, did he lose any wages? Did he miss work? But the statute for the presumption to apply, it starts out by saying any condition or impairment of health caused by hypertension. So what is the condition or impairment that was caused by the hypertension that would be presumed?
Other than 2 days of missed work?
I don't believe there were any, Your Honor. There was no end organ damage found that's typically associated with hypertension. Nothing, essentially.
I mean, the statute cannot mean, with that language, can it, that every single covered employee who has hypertension, high blood pressure, gets treated for life and is a workers' compensated claimant?
Well, it certainly would be the appellant's position that no, that is not what the statute means.
But you didn't raise that. You didn't argue that.
Well, what we did argue was that the expert medical advisor conclusively opined that whatever his condition was, it was wholly caused by non-occupational
Yeah,
factors.
but that's not what the statute says.
Right.
The statute doesn't establish the presumption with respect to whether the work caused the hypertension. The statute focuses on the condition or impairment that was caused by the hypertension that was then it's the impairment or condition that resulted in partial or total disability. So what is the condition or impairment of health, or impairment or condition of health that resulted in the partial disability?
Well,
Which
the
no
appellant-
one argued, it seems like, including you,
Well-
before the JCC.
Well, the appellants argued that there was no compensable hypertension because there was no disablement or impairment due to the hypertension. That
But
was
it's not, the question is not whether it was due to the hypertension. The question is, was there an impairment of health or a condition of health or an impairment that resulted in the partial disability? Now, assume he obviously has some sort of hypertension.
Well, the appellants assumed that the claimant was alleging that it was the days off of work.
Right, so 2 days off of work
Which
because
we-
of, 2 days off of work because of a high blood pressure reading. And he's entitled to a lifetime of treatment for high blood pressure when there's no other impairment or health condition?
That didn't seem right to me either.
Well,
However-
apparently that's not what the legislature thought either.
Right, and we argued that, it was rejected, and our only alternative at that point was to.
You did argue that, you said? You didn't
We
argue it in-
argued that.
You didn't argue it in the brief that I saw. You didn't argue in the brief that I saw that, look, it's irrelevant whether his hypertension was or was not caused by apnea, being overweight, smoking, because he had no impairment. Getting a high blood pressure reading and having the doctor to tell you to take 2 days off while I assume he took the 2 days off while the doctor did what?
That wasn't explained. He simply, they raised the Rocha case and said that, well, whatever the doctor says, if he's told to
Understand.
take off
But
work, then
why was he told by the doctor to take 2 days off?
well, that was never established. We had actually objected to the note coming in, but it was allowed in.
I mean, I wrote a dissenting opinion once and regarding high blood pressure readings, and one of the arguments about in that case was, hey, white lab coat syndrome, people get high blood pressure readings. This was regarding whether there was an exclusion for the qualification for the compensation. That everybody gets high blood pressure readings occasionally, sometimes just your doctor walking in there or, being put on the machine. But,
Yes, sir.
but very few people, or not, unfortunately, too many, but most people that get a high blood pressure reading have zero consequences from that. It seems like on this record, the claimant had zero health consequences from whatever the high blood pressure reading was.
That was,
I mean, he's not being treated for any kind of heart condition, right?
there was apparently no left ventricular hypertrophy, no the other attendant.
But no heart condition. He's not in any way injured from the hypertension, whatever the cause of the hypertension is, correct?
That's what the appellants argued.
No, I'm asking as a matter of fact, not what the arguments are. Is he injured, was the appellee injured as a result of the hypertension? Was he impaired?
Well,
Not whether a doctor said take a couple days off from work. Was he impaired? Did he have to have treatment for a heart condition?
he had no treatment for
For
a heart condition.
condition.
He was simply provided medication. for
And I
the
think that's what
hypertension.
Bivens says, you have to have arterial or cardiovascular damage or component. So I didn't see that anywhere in any doctor's deposition?
No, Your Honor, I don't believe there was any, they did not establish that.
I mean, has there been a whole kind of assumption over the decades, other than Bivens, that if you have a high blood pressure reading, that's it? You're going to get compensated and it's a workers' comp claim? Everybody, at some time or another, has a high blood pressure reading.
That's true. As a matter of
Almost.
fact.
I mean, there are a few fortunate souls that never have a high blood pressure reading, but
They may-
almost everybody at one point or another, when they do their annual checkup, oh, your blood pressure's a little high. But if there's no impairment or no concern,
So, yeah, I mean, on that, I mean, you have one argument in your brief, and it's focused on the EMA. But doesn't the claimant have to establish sufficient proof to get to take advantage of the presumption in the first place? Has to hit the aspects of the statute before the presumption applies, right?
I would agree with that.
Okay. And was there sufficient evidence to support the JCC's determination that a condition or impairment of health was caused by hypertension that resulted in a partial disability?
Well, the EMA did say that he had been unable to work based on the note provided from his authorized.
But that's
or
not.
Not authorized.
Are you saying that it's assumed in the industry that if a doctor says, don't work for a day, that is a condition or impairment of health? Because that sounds like disablement, maybe. So he loses wages for not going to work. But what's the condition or impairment? And did anyone testify that, or put in a record, anything in evidence that shows that the claimant suffered from an impairment because of the hypertension?
Apart from the note from his doctor, there was nothing in the record. And
But you don't argue that as an alternative basis for the JCC committing error.
right, because the JCC relied on Rocha to say that that is sufficient to produce the presumption.
and I'm just curious, maybe this is a unusual question, but he misses 2 days of work. He's compensated by the police department, right? I mean, that's sick leave, right?
That's correct, Your Honor.
So he doesn't lose any wages for 2 days, right?
That is true, Your Honor.
So there's no impairment, there's no condition of health, there's no, I mean, I assume the city of Miami didn't say, oh, no, we're not going to pay you, we're not going to allow you to take sick leave for 2 days when you have a doctor's note. There just doesn't seem to be any injury or damage or problem in this entire case. And I'm beginning to think that this is a common practice that, oh, you have hypertension, therefore you have a valid claim, even though there's no health concern whatsoever from the hypertension,
Well, I can only
other than being treated for hypertension, I
I
mean.
can only speak for myself, Your Honor, but whether there's an urban legend out there is beyond my ability to inform the court. I will tell you, though, that Rocha does present a problem when someone comes in with a note that says, take 2 days off of work for your hypertension. The trial courts are interpreting that as disablement and an impairment of health.
Well, I mean, that's two separate terms, disablement versus impairment.
Well, true. However, as in most cases, sometimes the, I guess, squashing of categories together creates ambiguity or new law. And so that is currently something that the defense bar has to deal with, which is Rocha. If you have a note that says hypertension, take 2 days off, that's going to produce a presumption.
I mean, is that a kind of a common occurrence that for those that are covered by the presumption, that any kind of doctor's note that says you have hypertension, that's going to present a potential claim?
Well, I'm not I'm not privy to the conversations the claimants have with the claimant bar, but.
I'm asking from your perspective,
Oh, from my perspective.
from the defense perspective. Do you see that occurrence
I see that a lot. I see a lot of notes from doctors that.
regarding hypertension?
Some regarding hypertension. Most often what you see is they go to the emergency room and they say, patient was in the emergency room, excuse him. It doesn't particularly say hypertension, and then the claim is filed saying, look, we have this note. That's what happens. Those are a little easier, though, because at that point it's not clear, and that's the Shacklet case. It's not clear why was he at the hospital? What was it for acute coronary syndrome that was later ruled out, and that sort of thing. Oh, he had hypertension as well. Okay, well, that's not disabling for hypertension. But if the note comes in and says, your hypertension requires you to be out of work for 2 days from, I don't know, could be an unauthorized physician who knows what his intentions are, that is often presumed to be compensable. The question would become, is it reasonable? That has not been addressed yet. And I was,
Well, you're in your rebuttal time. Thank you.
Oh.
If you'd like to save it.
thank you.
Thank you.
Good morning. May it please the Court. Ken Schwartz on behalf of the appellee, Mr. Aljordi. Not entirely where to start because you guys were focusing on something entirely different than what I was expecting. But it seemed to me, up until a few minutes ago, that the entirety of today's discussion was going to turn on the phrase that the appellants used extensively in their brief, more likely than not. It seemed like the entirety of their argument was that the JCC erred below because the JCC didn't relieve them of the presumption that the statute affords when the firefighter has a diagnosis of hypertension. And as I understood it, they're saying that the JCC should have accepted the testimony of Dr. Perloff, the EMA, when he answered a fairly loaded question that had him assume something to say that, yes, okay, it was more likely than not that there were some non-occupational factors that caused the claimant's hypertension. And the appellee submits that this was not sufficient to convince the JCC below that she should have said, yes, the employer carrier has met their burden to overcome the presumption, and therefore I can say that the presumption no longer applies, and without medical evidence of causation, the claimant should not be awarded the benefits. Simply put, the appellee's position is that the JCC had sufficient evidence to determine that the presumption applied, but the employer carrier didn't meet its burden to present a contrary set of evidence to show that there was a cause that was non-occupational in nature, and therefore the employer carrier should prevail on that issue.
So is it your position that, based on their brief, that they forfeited the issue of whether the presumption applied originally? And that
Absolutely.
the only question is whether the employer successfully rebutted that presumption?
Absolutely, and in fact, that is, I think, Roman numeral 3 of the answer brief, that the employer carrier did not raise a number of things that perhaps could have been addressed, including, for example, the origins of or the nature of the hypertension. There was the question of essential hypertension and whether it's covered pursuant to Bivens. I believe the case name is Holcomb, that addresses what I think you also pointed out, Judge Thomas, whether the essential hypertension was arterial or cardiovascular in nature, because if there's evidence to support that it is one of those two, then that is a form of essential hypertension that can suffice to support the presumption under the statute. I agree. I don't see anywhere in the record that there is a discussion of breaking down the essential hypertension into one of those two, I guess, subsets, if you will. It was pled in the petition for benefits in the appropriate way, but thereafter I don't think that it was ever raised again. So the appellee's position would be, to the extent that that's a material question, it's no longer relevant because the judge of compensation claims addressed everything that needed to be addressed below, and we're now on appeal and looking for error as opposed to things that could have been decided a different way below.
What's the rationale for reading into, the statute just says hypertension. It doesn't mention arterial, cardiovascular, anything. It just says hypertension. What is your understanding of the rationale behind adding those words into it?
Whether it would be appropriate to do so?
This idea that it has to be arterial or cardiovascular hypertension for it to satisfy the presumption requirement, or the statutory terms for a presumption.
I admit that's beyond my medical understanding. I don't
It's
know
not,
why.
well, it wasn't medical understanding. I think that's my point, is that it comes really out of the blue in a couple cases from this court. But are you aware of any legal analysis to support that statutory interpretation?
Well, obviously, the legislature could have listed any number of conditions that they were going to include in the presumption, and they narrowed their list down to the ones that currently are there. I can't speak to why they would have narrowed it down. They could have.
I'm not asking why the legislature was pretty clear as to what they said. They said hypertension. This court said, oh, well, it's not all hypertension, it's just
And maybe,
cardiovascular or arterial.
maybe this court said that because, isn't it rather an absurd interpretation of the language of the statute to find that a person who has a high blood pressure reading, but no health consequence from that, is entitled to a valid claim when the statute says an impairment or health condition caused by the hypertension? What was caused here by the hypertension?
Well, in this case, there was the letter from his initial doctor that he saw that said that he should be taken out of work for 2 days
Right.
for evaluation and so on. And Dr. Perloff, the EMA, although he testified that I personally wouldn't have written the letter probably, in speculation retrospectively, I agree that it was reasonable. And the claimant wound up not just taking those 2 days off, but the claimant was out from, I want to say, I wrote it down, from May 7th of 2020 to May 28th of 2020. And the JCC accepted that that was reasonable when she indicated in the final compensation order that she was saying that the claimant met all 4 prongs.
Excuse me, well, so why was the claimant out for those 3 weeks?
He wasn't feeling well.
Because of the hypertension?
I mean, was there
That's the
any
testimony,
evidence?
yes.
Is there any evidence that the hypertension caused that?
There is no testimony to contradict that the reason he took those days off is because he wasn't feeling well because of the hypertension.
Yeah, but isn't it your client's burden to show that the hypertension caused his not feeling well, such that he needed to take 3 weeks off of work?
It would be the claimant's burden, but I would submit that in the final compensation order, the judge addressed this and said that she was convinced. She said that there was evidence
By what?
from the claimant's competent substantial evidence in the form of his testimony.
Right, but what medical evidence was there? You have a doctor's note that says, yeah, take a
days.
couple days off.
And
And
Dr.
then he
Perloff,
takes a few more weeks off.
Dr. Perloff considered that, and Dr. Perloff didn't say that it was
I'm not talking
unreasonable.
about Dr. Perloff right now. I'm just talking, just generally speaking, what evidence did you present, or your client present, to support that, to make that link between the hypertension and this supposed impairment? He was out of work, he didn't feel well for a few weeks. Ergo, we're supposed to accept, or the JCC is supposed to, that's enough to support the JCC's conclusion that this elevated blood pressure was the reason that he wasn't feeling well?
I'm not sure what testimony would, or what evidence would satisfy you under this particular question, because you're saying it doesn't really matter what Dr. Perloff said, but isn't Dr. Perloff the end-all, be-all of what matters in this situation as the expert medical advisor?
Well, if we're talking about the presumption and whether the presumption should apply or whether it was rebutted, but my question is before that, let's assume that the employer has not forfeited that argument on appeal. What is the evidence that was presented by your client to hit the presumption in the first place? And it sounds like everyone's just assuming that if the claimant can show hypertension, that's enough. I mean, hypertension plus I missed work for a day, that ends up being enough. And I'm not reading the statute that way. I mean, correct me, how am I wrong on that? What am I missing?
Well, I think that the evidence that Dr. Perloff assigned a 2% impairment rating would be significant. So it's not merely a question of did he miss a couple of days because a prior doctor's note that the EMA said wasn't unreasonable to write. There is more than that. So as far as interpreting the statute, I agree with you. There should be some disability from the condition that is listed in the statute.
Not disability. That's disablement's different. So it's not a question of whether he was disabled. So he missed a couple of days of work or whatever. But what is the condition? Well, I think everyone seems to be assuming, well, he had elevated blood pressure, so he wasn't feeling well, and he missed a couple of days of work. But I'm not seeing that connection necessarily. Are you just linking it all together? It is enough in order to get the advantage of the presumption, to just show what your client tried to show, which is he had elevated blood pressure, he got a doctor's note that said he could take a couple days off of work, he wasn't feeling well, and then you have Dr. Perla says MMI is 2%. The 2% based on what? Because he has high blood pressure? What was the thing that's stopping him from doing his work? What's the condition as a result of the high blood pressure that's impeding his ability to work?
I don't know that I can answer that question, and I'm not entirely sure I know what I could say to convince you, because I don't know that that the doctors were saying that they understand his condition enough to be able to make such a direct link between one and the other. In fact, they were saying we're not entirely sure what caused his hypertension, but he has the benefit of the presumption because he has the condition that was listed in the statute. And the entire point of the presumption was to avoid certain amounts of litigation. It was to benefit society by creating a situation where people.
But how do you read, aside from the question of preservation, how do you read the language in the statute that Judge Tannenbaum cited, that the presumption applies when the claimant has a health condition or an impairment caused by hypertension? How do you understand that statute to mean?
Can you direct me a little more on the
Sure.
question?
In other words, doesn't that really mean, isn't the plain language of that statutory provision directed toward, for example, somebody who has a coronary condition, somebody who has to go in for a heart failure treatment, somebody who had disablement's been brought up, but aside from the legal question of disablement and lost wages, the idea that somebody has to go to the hospital and be treated for a heart condition. The legislature is saying that should the claimant have high blood pressure, we're going to assume that that heart condition was caused by the employment, not the hypertension. Isn't there a missing link there?
I don't know that I can
Well,
answer.
what do you think the statute means?
I think that there should be some connection between the listed condition and a disability of some sort, some residual, whether it's an impairment rating or a need for ongoing evaluation by a cardiologist. There should be some connection between one and the other. Otherwise, why be in the comp system? Why put this on the employer carrier at all? What's the employer carrier's role if they're not providing something that was in some way caused by an occupational risk?
So would you agree then that, let's not discussing your client's case, but let's say a person has high blood pressure, he's covered by the statutory presumption, he misses work for a week because the doctor says, I need to check this out, we're going to run a few more tests. He's certainly able to go back to work a week later, but he did have high blood pressure. The employer cannot overcome. Let's take a different case where there's no apnea and smoking and obesity. There's no other cause. Is that a covered claim under the statute? I mean, your argument here is that it's covered because the employer carrier didn't adequately rebut it. But let's say there's the hypothetical, there's no other cause of the quote hypertension, but there's no health condition caused by the hypertension. Is that a valid claim, in your opinion, under the statute?
I think it's a valid claim that the employer carrier won't have to continue to provide benefits for. So the mere fact that there is a claim that whether it's compensable or not doesn't cost anybody anything. It's just a statement that the law says that you should have the opportunity to be treated at the employer carrier's expense so that the burden doesn't fall on society. That's the benefit of the presumption and actually the comp system in general, isn't it? So if a person has a claim and they make the claim to their employer, they're given the opportunity to go to a cardiologist or whomever, and the medical evidence suggests that there is no disability of any kind, then don't they simply go back to work and the case dies on the vine organically?
Right. So here, did the employer carrier refuse to pay any doctor bill?
Not that I'm aware of.
Right. Did the employer carrier or the City of Miami Police Department refuse to agree that any of the missed work was sick leave?
I don't believe so. At least those 2 days.
Well, I mean, isn't your best argument to the plain language of the statute requiring impairment that he got a 2%? He got an impairment. But, you know, the Florida guides, which obviously we use for workers' comp, are pretty discretionary. You get a 0 to, I think, a 14% category for the doctors to assign impairment for these heart conditions. Here, it was 2%. And in looking at the depot, the 2% was assigned primarily because he was prescribed medication only. That still leaves me with the problem that, you know, we don't have the arterial or cardiovascular. We still don't have proof of a condition. The 2% was assigned based on the writing of a prescription. So I'm still having trouble getting past Bivens, for example, and Holcomb. So can you address that?
Unfortunately, the only way I can address it is probably going to be unsatisfying, and that is I'm appellate counsel in this matter, and this is a court of errors. I don't believe any errors were presented for this court to consider that would require reversal. Whether or not this case was everything that could have been presented was presented at trial, perhaps not. I don't think there is evidence of.
So basically, they've waived it. We don't have jurisdiction to consider that. It's waived.
To be glib about it, I would say yes, that is point 3 of the answer brief, that there were a number of things that could have been raised. And as the JCC pointed out, this was a hotly litigated case from very early on. On appeal, we have the employer carrier, the appellant, saying that it was error for the JCC not to rely on the EMA, but it's the same EMA that they tried bitterly to get excluded from the record below before the judge entered her order on awarding the
Well,
benefits.
just to be fair to you and to appellant's counsel, I'll ask a question about the issue actually briefed. And that is, let me ask you, why isn't the EMA's testimony that it's more likely than not that the apnea, obesity, and smoking cause the hypertension rather than work? Why don't they prevail on that argument?
Their burden, thank you for the softball, their burden was to show to the JCC that there was contrary evidence of a cause that was non-occupational in nature. There's a lot of use of the word factors, and I have an issue with the word factors because it really relates to risk factors. And although the appellants rely heavily on the Vaporus case, that's from 2007. In 2009, the court issued its opinion in Punske, which made it clear that risk factors are not enough. The risk of something happening does not equal the cause of something happening. And the JCC had the employer carrier had the burden of showing the JCC that there was some contrary evidence of a cause that was non-occupational in nature. But the way the wording of the cases that interprets all this plays out is that it has to be sufficiently convincing to the JCC. Well, simply put, the JCC wasn't convinced. This is a question of how.
What about our cases that say an EMA's opinion is nearly conclusive? I mean, maybe I misunderstood the question and answer in the deposition, but I thought it might be pretty clear that the EMA was saying these other factors, obesity, apnea, and smoking, are more likely than not the cause. Is it your point that the question referred to risk factors and not cause? Because I thought I saw the word cause in that exchange.
The way the question was worded was that the attorney asked the doctor to assume that these other things, obesity, smoking, apnea, whatever it was, came together to have some sort of effect. And assuming that that happened, would you say that the result was more likely than not non-occupational in nature? And he thought, yes, okay, I'll say that it's more likely than not the not the job, if you phrase the question that way. Essentially, the question as I read it is you're kind of putting the non-occupational on one side,
But he did
non-occupational
have
on the other.
apnea, he was obese, and he did smoke.
That's
So,
the evidence.
and then the EMA says that's more likely than not the cause of the hypertension.
I don't think that that's exactly how I would state that.
Do you have the
answer.
question and answer in front of you?
I did a moment ago.
I'll give you a moment. Take your time.
Yes, I believe I do.
Thank you.
On page 2 of the initial brief of the appellants, they quote from page 498 of the record, And the question reads, let's just assume for a second that that's not the standard. Let's just assume that it's a preponderance of the evidence that more likely that a number of conditions working together caused his hypertension. Would you agree that it's more likely that the claimant's age, obesity, the fact that he's a male, possibly sleep apnea, working together with other non-occupational genetic factors caused his hypertension? The answer is, I would say that it's more likely than not that those caused his hypertension than his job. And I would submit that the first half of that question sets up the answer. It asks him to assume that these things work together and caused this situation. So the assumption is he must assume that it caused it. I don't think that the doctor's testimony ever was that anything caused anything. He said, I can't determine what caused the hypertension, and I think that's crystal clear. I don't think that he said anywhere in there that any particular non-occupational cause existed. He said, I can't tell what they are, but if you want to phrase it that way, okay, it's more probable than not, probably non-occupational. But probably non-occupational doesn't say that there's any specific cause. It doesn't say that there's any combination of causes. Never once did he say the apnea caused it or even contributed to it. What he said was the apnea might have contributed to it because these things can happen.
But
And that goes down the list.
But that gets back to the original question, and that's where the statute ends up mattering, as it typically would. The it. No one's defining the it. So the apnea isn't more likely than not caused it. Obesity may more likely than not caused it. It sounds like everyone's assuming the it is the hypertension, but the statute's not expecting that. The statute's expecting a showing that, and this is, it actually does get back to the employer's answer, or excuse me, the employer's initial brief and the argument they are making, which is, it all goes back to what does the employer have to show in rebuttal? And it sounds like, at least reading the statute, the employer has to show, present some evidence that a non-work circumstance or condition caused the condition or the impairment that then led to the disability, not the hypertension. So what is what's the argument? I mean, we're back to the question originally. Can you address, we were talking about what the EMA said and all these other conditions. It sounds like the employer has presented some evidence to suggest that these other conditions, not work, cause whatever impairment you've described, which is he took 2 days off of work or maybe he took 3 weeks off because he wasn't feeling well.
Well, your time's expired, but I will allow you a minute to answer that question.
Thank you, Judge. Again, I'm going to perhaps give you an unsatisfying answer, which is that the JCC was tasked, or the JCC was challenged to accept evidence from the employer carrier that there was a contrary condition that caused the disabling condition, and that evidence simply wasn't presented below. So if the presumption works in favor of the employee, then the burden shifts away from them. There's no more causation that the claimant needed to present. So the claimant's case was already, the prima facie elements were already met, the presumption applied, the claimant was done as far as causation was concerned, it worked in his favor. The burden shifted to the employer carrier to convince the judge that there was something non-occupational, and they simply weren't able to do that. Excuse me?
That caused what? Non-occupational condition that caused what?
That caused the disabling condition, that caused the disability, and I know you don't like that word in this situation because you refer to it as the money benefits, but that created the connection that I was describing to Judge Thomas. There's got to be a causal connection between one and the other. The occupational risk has to lead to some negative outcome. But in this case, we do have the 2% impairment. We do have the couple of days off work. We do have the need for him to see a cardiologist for ongoing evaluation. So there is an end here. There are two connecting points. There is an occupation that is covered by a presumption if the other elements are met, and we have the need for him to receive workers' compensation benefits. And I think that those two things are connected enough through the evidence that the JCC accepted as competent and substantial in convincing her that the claimant was entitled to the presumption and the employer carrier was unable to rebut it.
I'll allow you a brief conclusion, and Madam Clerk will give the appellant 2 additional minutes. If you'd like to make a brief conclusion.
I think I summarized my position, and to the extent that I haven't, I would rely on the briefs. Thank you for the opportunity.
Thank you. Thank you, counsel.
Thank you. I would just like to begin the reply by reading the exact language from the record. It actually begins a question before, because it is the appellant's contention that the EMA was laboring under an inaccurate understanding of what his role was in proceedings. He thought he was looking for a specific, clear cause for it, the hypertension. And I asked him, okay, it looks as though in your report that you were looking for a specific non-occupational cause that clearly caused his hypertension in order to say that the EC rebutted hypertension. Is that fair? Answer, yes. Let's just assume for a second that that's not the standard. Let's just assume that it's a preponderance of the evidence. So more likely that a number of conditions working together caused his hypertension. Would you agree that it's more likely than the claimant's age, obesity, the
So
fact...
this hotly contested, we just heard the question
Right.
and answer.
That's the
So
part.
So this hotly contested case, which I assume, knowing that there are great lawyers on both sides, was all about a person with a high blood pressure reading that was told to miss 2 days of work with no evidence that the employer refused to provide sick leave for those 2 days or the other 3 weeks. All of this is centered around high blood pressure readings with no impairment or health condition. As Judge Thomas pointed out, the 2% is based on the prescription for high blood pressure. There is zero evidence that the claimant suffered any injury, health condition, or other impairment from the hypertension. Is that correct?
That's correct. That's our contention, Your Honor.
You think that's the way the statute's supposed to operate?
I don't believe that's the way the statute's supposed to operate.
But that's the way it's been operating, right?
Well-
That if you're a covered employee and you have high blood pressure, and a doctor says, let me check this out, let me do an additional test, let me see if there's any problems resulting from this, i.e. an impairment, and then there aren't, that a person then is entitled to a claim.
Well, as I indicated before, ROCHA is apparently a problem for many employer carriers, and that's one of the reasons why these cases, as they develop,
And in fact, the prescription for the high blood pressure medication is almost always going to be covered by the employee's health insurance, correct?
I would assume.
So nobody's arguing that the employer or carrier in this case said, we're not going to pay for the prescription. Or is that a problem? Did that occur?
I don't believe that he has a problem paying for, I don't know what it might be amlodipine or lisinopril, which is pretty...
Is there any evidence that in the record that shows that the prescription for his meds to treat the high blood pressure resulted in a change in his classification at work, that he had to have work restrictions, and suddenly he's losing wages in some way because now he has a prescription for high blood pressure?
Well, apart from the no work notes from his personal physician, I'm not aware of any. I don't anticipate, because...
In other words, the city didn't say, well, we're going to ask you to be a school resource officer, although that obviously can be very dangerous, as we tragically found out in Florida. That, in other words, he wasn't reclassified to a position that he didn't want, or told, okay, you can't do X, and that was something he loved doing or she loved doing, and no, you're not going to be allowed to do that because of your high blood pressure?
No, and the medications involved, I've never seen that happen, either amlodipine or some other hypertensive drug. I mean, you might have that with a blood thinner for other cardiac conditions where, obviously if you're fighting with people, that might become a problem, but not with blood pressure medication. The reason that these cases turn out the way they do is, again, ROCHA seems to present a problem, which is why the employer carriers typically will look for additional defenses as well. The affirmative defense of rebutting the presumption, which we believe we've successfully shown here should apply because of the presumptively correct opinion of the EMA.
Are you saying that this court is causing problems by looking at the
Yes,
statute in
Judge,
a way
this court is
that?
causing, no, absolutely.
No, I mean, a perfectly reasonable answer would be yes.
Yeah, I would-
Potentially, call it what you want, and maybe causing problems is the wrong phrase. But I guess let me ask it this way. What can this court do to encourage the bar and the JCCs to pick up the statute and apply the statute in cases as it's been written?
Well, first of all, I think it's the interpretation by the defense and claimant bar that's necessarily the problem, Your Honor, because I do know that the court indicated in Rocha it's got to be a reasonable reliance. And so it would be up to me as defense counsel to show that's not a reasonable reliance. And so that, I don't think Rocha is the problem, it's the interpretation of Rocha.
And it's not just Roach. I'm talking about just generally, because this entire case has been litigated, and you both have used the phrasing, the hypertension was caused by something. And if you read the statute, the caused by follows the hypertension, the term hypertension, and is referring to the impairment.
In
Has
other words-
nothing to do with work causing the hypertension.
In other words, the entire purpose of the statute seems to be that these employees that are in these high-risk positions, should they suffer an injury or a health condition, such as a disabling heart condition, some kind of coronary condition, and there's hypertension, that condition itself is going to be presumed to be caused by work.
I think that is what's understood, although the statute is clear. It isn't the hypertension itself. It is the disablement or impairment caused by the hypertension. For our
Thank you.
purposes,
Would you like to make a brief conclusion?
yes, I just wanted to say for our purposes, this defense counsel, it's proving that the hypertension is not caused by work, and therefore that then the disablement wouldn't be caused by work, or the impairment of health wouldn't be caused by work.
Thank you, counsel.
Thank you.
Court is in recess.
All rise.
You know, we're home alone.